Good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bong-soo, we will cover a very important court ruling, Supreme Court ruling that was published by the Mail Daily, Labor Daily, and it's regarding the consideration and judgment of the labor status of the drivers, taxi drivers. So could you explain the background of this court ruling?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. That is a very important Supreme Court ruling decided on September 27th, 2024. So this ruling is regarding some the car driver how do you call 대리운전? How do you call in English?
Replacement of the owner driver.
Yeah. So it is like a replacement driver or alternative driver. Like when the owner of car was drunken and could not drive, then they are asking like a replacement driver to come and drive on behalf of them. So there are 160,000 such repair or some replacement drivers. They are working based on some. They belong to certain company. So the company provides some particular app. So those app customers called this replacement driver company, and then such a replacement driver come and support driving on behalf of the owner. So in the case of one area in Busan, such drivers got together and made a union, but company rejected. They are individual contractors or individual business owners, so they are not qualified for making labor union. However, the Supreme Court ruled against their request because this case it deal with whether replacement driver can be an employee or worker under Labor Union Act. So of course they are not employee under Labor Standard Act. In order to be a employee or worker under Labor Standard Act, they must belong to one company, and also they must work following company regulation and receive their wage in return for their providing labor services. So in the workers under Labor Standard Act provide two requirements, like they have a direct employment relation with the employer, and also because of their labor service they are receiving wages. So economically or some individually they are engaged to this employment contract. However, the workers under Labor Union Act, it is still different. Those people who provide their labor and without the employment contract or some special supervision or control from one particular employer, they just provide the labor, and instead in return for that they receive income or wage. So such a case is they don't belong to the concept of workers under Labor Standard Act, but they belong to concept of worker under Labor Union Act. So those replacement drivers is regarded as worker under the Labor Union Act. That is the court ruled, Supreme Court ruled. So the reason is they exclusively providing the labor service to particular employee. Then in return for that they receive their income or wage. So this relation, they are regarded as a worker under the Labor Union Act, even though there are no employment relation. So that is a reason.
I think this is a very meaningful court ruling by the Supreme Court, especially as you have detailedly explained the difference between the Labor Union Act and Labor Standard Act, the concept of the worker or employee. So in future, not only this replacement driver, but in different job circumstances, for example, I mean delivery people or caddy, those people can be are also considered as labor under the Labor Union Act.
Yes, the Supreme Court continuously has made same conclusions about some workers under the Labor Union Act. So those people, they don't belong to certain company, but when they provide their labor services, then in return for that they receive income or wage. Those people, they are regarded as a worker under the Labor Union Act, such as the golf field caddies, also some delivery men that belong to certain delivery company. Also this replacement drivers like this one. Yeah. So the reason why they decide to make a labor union, the reason is if they provide their labor service individually, then working condition they are always subject to the control and they cannot protect themselves enough. So they need to improve their working condition after they working for a certain period of time. So only labor union can make a big voice. The individual voice cannot make any negotiation with that company. So to negotiate their working condition with the company. So they need to have a big organization or association we call labor union. So that is the reason why they decide to have a union, because union is protected by the Union Act. Also they can negotiate and they can make the collective agreement. Then through collective agreement they can improve their working conditions.
So I think in future, as you have explained, under the Labor Standard Act, the concept of employee or worker is like a traditional concept, which is the worker has to be employed by a company and work inside the company. But in such case, it's a different concept, and this is considered as employee by the Labor Union Act. And I think it's a future job environment.
Yes,
status.
Nowadays the job has become very various. Also there are many different types of jobs. So employer, they don't want to hire, but they want to outsource their work to the other people, or they want to control those people who are working for them indirectly. So in that case, those workers who belong to certain group cannot protect their legal right. So workers under Labor Union Act is more wider and more
broad.
So that means the protection right can include more through this promotion of some labor union related workers. So also government policies, they try to support these workers to make a labor union. That is the way they can to make their some entity that is we call labor union that can help them by themselves.
I see. Thank you very much for your comment.
Okay, thank you for watching. Okay, bye bye.